Yes, Miss Jolly.
Thank you, my lord. My lords, my lady, we rely on our written submissions. Sorry, I should have just said that I appeal with Ms Masters for Protect, and like many other parties in this case...
I presume you're not being paid either?
The presumption would be correct. The presumption would be correct.
The only advantage is that this is the warmest room in the building.
Possibly the tightest packed with this number of parties too.
Yes.
My lords, we rely on our written submissions, which you have seen. What I'd like to do in my limited time orally is focus on our specific contribution, which is to assist the court in how to approach the exercise of statutory interpretation in relation to sections 47B and 103A through the prism of the purpose of the whistleblowing legislation, which Protect submits is to safeguard the public by empowering whistleblowers to speak up safely about suspected wrongdoing in their workplace, whether they are workers or employees. And you've seen that in our written submissions, paragraph 5A amongst others. The party submissions over the last 1.5 days make clear that the meaning of section 47B2, which maps the relationship between parts 5 and 10, remains highly contested. Today, Protect invites the court to reach the following overarching conclusions. A. Osipov is correct whether on ratio, reasons, or by result. B. Employers are vicariously liable for their agents or co-workers under section 47B. C. This means employees can always rely on sections 98 and sections 103A in part 10 and section 47B in part 5 where the detriment is dismissal. I'm going to return to section 98 shortly when I come to address the scheme of the Employment Rights Act. D. All that is excluded is a direct claim against the employer under section 47B for its own act of dismissal. And then E, in other words, together, parts 5 and 10 create a seamless mechanism which ensures the universally effective protection of workers and employees. Now, to reach those conclusions, I intend orally to develop 3 stages in Protect's analysis of section 47B2, leading to them. These are, firstly, the golden rule is that the courts must give legislation its plain and natural meaning. However, that rule does not assist in these conjoined appeals, since there is plainly ambiguity within section 47B2. Indeed, we count at least 6, possibly more, alternative readings of section 47B2 canvassed yesterday and today. Second, the absence of a golden rule interpretation means that the court must look to the canons of statutory construction in order to understand the relationship between part 5 and 10, as dictated by section 47B2. Protect invites the court to find, much like it did in Osipov, that the most useful canon when it comes to resolving the ambiguity within section 47B2 is to construe it purposively as it currently stands and in light of the way in which section 47B has developed. That last point engages with the case law that recognises that legislation is a living instrument. You haven't heard much about that yet, but it's important and I'll return to it. And then thirdly, through that purposive prism, the analysis in Osipov, supported by the employees in the conjoined appeals, is right, because it does promote public safety by creating a coherent analysis of the relationship between parts 5 and 10, such that there is universally effective protection for workers and employees.
Are you aware whether there was any attempt to appeal from Ossipov?
There was no appeal from the Court of Appeal. There was no appeal.
No, nor any attempt.
I don't think there was any attempt.
No, I couldn't find.
Yes,
I couldn't find one.
There was no attempt. Both Mr. Milton and I were counsel for.
Yes, right.
In
Well, that's what we assumed because we weren't told otherwise.
Now, my lords and ladies, before I expand on those 3 points, I am alive to your comments yesterday about just some context on the statutory scheme, and the court has heard a lot about it. So I just wanted to add a few additional comments which we think are critical context in this appeal. And if I could take you in supplementary 1, please, first to page 92. That takes you to part 10 and the start of part 10. And you see at page 93, at section 94, that is the generic right not to be unfairly dismissed. And then you see at section 95 the definition for dismissal, and this includes both express dismissals, but also where employees resign in response to repudiatory conduct. That's 95(1)(c). And then if you go forward to page 95, you see section 98. And this section sets out what employment lawyers usually refer to as ordinary unfair dismissal. And for a dismissal to be unfair on this basis, the unfairness can simply be a procedural error, such as failing to follow an internal process. So it could be as simple as that. And employment lawyers usually call that procedurally unfair dismissal. And that falls within section 98. Compensation is capped, subject to a changing limit every year. And where the dismissal is simply procedurally unfair, employers very often successfully argue that compensation be limited to the period of time it would have taken had a fair process been followed. So this may just be a matter of weeks. The other distinguishing fact about it is that employees need presently 2 years of service for the ordinary unfair dismissal claim to kick in. By contrast, if you then go forward to page 97, you see the 103A provision. Now, automatic unfair dismissal, by contrast, is all about the reason. It's about the sole or the principal reason for the dismissal. So on the prescribed ground of protected disclosure, the causation test is where the sole or principal reason is the protected disclosure. The dismissal is automatically unfair. Compensation is uncapped under this provision. I want to step back for a moment to reflect that both sections 98 and sections 103A form part and are in part 10. The test of both unfair dismissal and automatic unfair dismissal have a causative test that is the sole or principal reason. That is key. That is central to our submission. I won't take you to the table at the back of our submissions, which I've already pointed out to you.
Well, it's helpful. I've
Thank you.
reviewed it. Thank you.
Let me then turn back to the 3 points that I wanted to develop. So point 1 is the golden rule. The golden rule of construction is where the language is clear and explicit. Words must be given their ordinary meaning. I don't propose necessarily that you turn it up because you've seen it a lot over these 2 days, but section 47b(2) is at page 75 if you want to have it in front of you. How does that golden rule work in the context of this provision? We say, on the one hand, it is plain that section 47b(2) is intended to govern the relationship between sections 98, 103A and section 47b. We don't think that that's in dispute. If you didn't have section 47b(2), those provisions, all of those provisions, would bleed into one another insofar as a claim was by an employee and covered the factual territory of a dismissal. It's well accepted, beyond, both within the ERA and beyond that more broadly in employment law, that dismissal is but one form of detriment. And if I could turn the court, please, to the Core Authorities Bundle, tab 1, page 3. This is the case of Melia that the court has looked at over the last couple of days. And you'll see in paragraph 15, which is on page 8, a paragraph that the court has already seen, that it was in Melia that the Court of Appeal first identified this point about the governance of the provisions. And in paragraph 15, you can see just below E, Lord Justice Chaddock said the sections would in any event be read together, if only because they are now sections in the same Act, the 1996 Act, and then goes on to make the points that we can all see there. I would add to that sentence that section 47b would also, but for some guardrail mechanism, bleed across section 98(2), covering ordinary unfair dismissal for employee claimants. And that's the point to which I will return when I look at one of the competing interpretations proposed in this appeal concerning the effect of section 47b(2) in practice. Of course, Melia is now, we say, out of date, in the sense that section 47b has evolved considerably since then. And my learned friend, Mr. Jupp, set out some of the way in which those provisions developed. We, of course, now have the related provisions in 47(1)A to 1E, which didn't exist at the time of Melia, as explained by Lord Justice Underhill. You needn't turn it up, it's paragraph 85 of Ossipoff, and 85 to 90 of Ossipoff. But we say that Melia remains good law on this point, on the governance of the provisions. But beyond the intention of section 47b(2) on the governance of the relationship between sections 47b, 98 and 103A, how it's intended to operate in practice is a matter of controversy. Put another way, the golden rule of statutory construction does not offer us an easy solution to section 47b(2) because there is no plain and ordinary meaning. And I can illustrate this. Yes, I'm going straight to it, my lord. I can illustrate this by reference to at least 6 different interpretations of that section, according to the people in this room alone and the case law they rely upon. And so if the court will just bear with me, I'm just going to go through these with the first couple with a little bit more detail. So the first interpretation, interpretation 1, is my learned friend Miss Matraghi Casey's one route to claim dismissal approach. That's the phrase that she used yesterday, orally. And my note of her explanation of section 47b2 is, on its face, it has a plain meaning. It excludes any claim for dismissal, including section 98. Now, that is also Mr. Bidnell Edwards, my learned friend Mr. Bidnell Edwards, what he terms in his skeleton, the section 95 approach, in which he's reserving for the Supreme Court if we got there. Now, the starkness of interpretation 1 is really worth noting, because an employee ends up being completely shut out of section 47b and relegated to just section 98 and section 103A, and that may be relegated to just section 98 in practice and in many examples, because they cannot meet the high causation threshold in section 103A.
But just pausing there, that may be a stark interpretation, but why isn't it correct? Why can't that intention be attributed to Parliament?
Because, as I will go on to explain, my lady, that doesn't begin to meet the purpose of the whistleblowing provisions.
How can you have a purpose that floats free of the actual language that Parliament has used? This is my difficulty with all these arguments. Provisionally, it seems to me, the language of subsection 2 couldn't be clearer, and the arguments I've heard to the contrary are all arguments that say, oh, well, you know, there'd be more protection if it said something different, but it doesn't.
Well, with respect, my lady, and I hope you may indulge me a little bit.
No, of course. I'm looking for help.
Yes, indeed.
That's why I'm explaining the difficulty.
Yes, indeed. And what I'm about to show you is that there is certainly more than one meaning. And we know that, and I'll go to that in a moment, but we know that just at least because Osipov, at the very least, Osipov has given it a different interpretation. So we know that it's capable of bearing multiple meanings, at least more than one meaning.
Well, if the reasoning in Osipov is correct.
Well, possibly, but what we say is there is sufficient ambiguity, and I will set them out in all the interpretations in just a moment, but we say there's sufficient ambiguity in the provision.
Well, I'm listening.
And then, if you like, at point 2 and point 3 of my submission, I will then rely on the other canons of interpretation to demonstrate why those should be used, particularly purpose, the living instrument, and others.
Yes, but that's all further down the line.
Yes.
If you persuade the court that it's ambiguous.
Well, I wonder if the best way is, can I give the court a couple of examples of why I say if you use this interpretation 1, it ends up defeating the purpose.
Well, but again, we're in this kind of infinite regress. The purpose is primarily to be derived from the words that Parliament has used.
Well, I think, yes, and my point is that my point is, effectively, that there are, my lady, you may not agree with me, but we say there are at least, it is capable of bearing more than one meaning. And we see that because of Osipov, and we see that, and I'm going to take you to them, the different interpretations in this room. So, let me illustrate the starkness of the interpretation with 2 different examples. Example 1 was the example, let me build on it, that my learned friend Mr. Jupp gave the court. And you'll recall he said, the employer is a local authority, the line manager dismisses the employee for misconduct, but notes also that he was a troublemaker. And that's a reference to a previous protected disclosure.
Yeah.
the Employment Tribunal finds that both are reasons for dismissal.
Yep.
And so necessarily he fails on the Section 103A test. And if Wicked Vision is right, he has no claim under Section 47B.
Yeah.
That's why that's why he would want to, because it's a more realistic test. And what you also see is, well, I'll come back to that. So that's one example, was on Mr. Juck's example. But we would posit a second example, which is perhaps even more stark. Imagine if the claimant is successful in only the ordinary unfair dismissal because there was a failure to follow the employer's misconduct process. Now, on interpretation 1, that might lead to the successful claim, a successful claim under Part 10.
Yep.
In other words, they won the ordinary unfair dismissal claim, but they're shut out of Section 47B entirely because of that, and they can't access the Section 103A test. Now, that is a dilemma.
Well, you don't mean they can't access it, you mean they can't meet the test under Section 1.
They can't reach it because there was 2 reasons for the dismissal.
Yes.
They couldn't meet that high causative threshold. Now, just pause for a moment. Workers never have to grapple with that dilemma. There are no
because they don't
caveats.
have the right not to be unfairly dismissed, which is why they have the protection conferred by 47B.
And the point that we make for Protect is that in those circumstances, the right to ordinary unfair dismissal is flimsy. For example, they may have won the ordinary unfair dismissal claim, but it may just be, for the reasons I pointed out this morning, procedurally unfair.
Yeah.
They may be entitled to a few weeks of compensation only, a few weeks of pay as compensation. And they are shut out of being able to rely on the Section 47B test in a way that a worker simply wouldn't be. So
Because
on that, but on
the
that,
worker doesn't have access to Part 10. I mean, that doesn't seem to me to be shocking or surprising.
well, but what is surprising about it is that you end up with workers having a far superior protection to employees in those circumstances. And that, it seems to me, is a very surprising reading of the provisions.
Well, only on some quirky facts. If you are an employee and your claim under Section 103A succeeds, you've got a jolly good remedy.
Well, I think, my lady, what I'd like to do is, I won't take you to them, but I would refer you to Sibylle Raphael's witness statement, where she sets out not quirky examples, but many examples of actually where this happens in practice. Because Protect's experience is that in practice, that causative test is too high, and employees frequently cannot reach it. So that if they don't have access to the Section 47B provisions, they are effectively shut out of whistleblowing protection in a way that workers simply aren't. And that, it seems to me, is a very surprising
Well, but they're not shut
interpretation.
out from whistleblowing protection, because if they're making a claim about a detriment that doesn't amount to a dismissal, then they've got the same protection as workers, as I understand.
Yes, but in respect of a dismissal.
Yes.
Yes, but workers, in respect of a dismissal, don't have to meet any of those obstacles.
But they don't have any of the remedies that are conferred by Part 10.
But I think, my lady, where we are at loggerheads, perhaps I could say,
Yes.
is because you say that on the assumption that there is only one natural meaning, and so then you say in that case.
This jolly takes us back to the point that, speaking for myself, an argument about the meaning of the words, the plain meaning of the words, doesn't allow us to get into purposive matters. It doesn't allow us to get into absurdity issues. It doesn't allow us to get into anomalies and unfairnesses and so forth. That's a different sort of argument. Perfectly understand. But what I think you haven't so far done is to just take us to the wording of the subsection itself. and just explain on the words alone.
Yes.
Not on what's fair and what isn't fair.
Yes.
What the results are.
Yes.
Because we can, as I think you told us, only get into that sort of discussion if we were satisfied that the words on their own don't automatically lead to a particular conclusion, regardless of what this court has said on previous occasions. We have to make our own mind up about that.
Yes.
Because of the appeal. So I don't think arguments based on consequences really work at this particular stage in the analysis, and I think that maybe lies behind some of my lady's questions a moment ago. So keep within the boundaries of the subsection and tell us what it means.
Well, okay. So I have in front of me, on page 75, the subsection. Yes. There are, just bear with me for a moment. So what we say is, on the face of it, section 47b2 is both a mixture of certainty and ambiguity. So first of all, this section, in the first line, directs the reader to section 47b, that is certain. Does not apply, we say has ambiguity. For example, a natural meaning of does not apply is does not relate to or does not concern. Or it could mean something stronger, like does not arise or has no effect. So for example, there are within the Equality Act very clear disapplication provisions. I'll give you the example of section 71 of the Equality Act. I'm not sure if you've got it in the bundle. We may need to hand it up if so. But what we say is that it can have those different shades of meaning.
So that would be an ambiguity that applied to every single one of the 47, section 47s, which use precisely the same words. C, D, yes. E, F, they all say does not apply.
Yes, it could be that. It could be that.
Okay.
Well, it must be. If the same language is used in all those provisions, it must have the same effect in all of them, mustn't it?
Yes.
Right.
And then the next section is where the qualification on the instruction does not apply. I wonder if I could just short-circuit this for a moment. I can go through each of these provisions, and my lady, your point about this language will be correct. And I think that's why what I really wanted to do was say to you that there have been these 6 interpretations of the language, of that language, of what it means, of even what B means. The detriment in question amounts to dismissal within the meaning of Part 10. Those are the words. The detriment in question amounts to dismissal within the meaning of Part 10. What Ms. Matraghi says is that means any dismissal within Part 10, any dismissal, ordinary unfair dismissal and automatic unfair dismissal is caught, and you can't have that provision.
Yeah? What's wrong with that? Dismissal within the meaning of Part 10.
I think
the concept of dismissal is defined in Part 10, and you look at Part 10 to see what Part 10 has to say about the concept of dismissal.
My lady, I would like to just set out the interpretations for all of them, but what I can do is say to you that that is why you cannot read in section 47b2. You cannot read that without the full legislative, social, purposive context of the whole provision. Because as Mr. Jupp pointed out, this is a very unique provision. Section 47b, 1a to 1e, post-Fethett, post the amendments, now looks different. And what Lord Justice Underhill was saying in Elisabeth, and what we support, is that you have to look at it, you have to read section 47b2 in the different context of what section 47b2, section 47b now looks like. And what section 47b now looks like is a very unique provision which offers a different form of liability co-worker liability in section 1A and section 1B in a way that no other provision does. And so what we say is that because of that uniqueness, you can't just say this has to be the same as in every single other provision.
So are you submitting then, please, just so I get this
Yes, absolutely.
clear in my own head and stuff, are you submitting that this language, which recurs throughout the relevant part, means something different in section 47B from what it means in the other provisions?
Yes, I am.
Right.
I am.
Because I thought a minute ago you were accepting that it must mean the same throughout.
Just to be clear, that what I'm saying is that the language, the section does not apply. Yes, that those words appear in every section. What I'm saying is you cannot read this section without the whole context, and to that degree you have to look at the context of the section. It cannot be divorced from the uniqueness of the provision that now exists. In other words, it is a different kind of section. The whole section 47B is not the same as the other provisions within Part 5.
We understand that submission. We understand all the points about it being unique and all the rest of it. But what I'm still struggling with is whether you accept or you don't accept that the language of 47B subsection 2 must mean the same wherever it recurs in the same part of the same legislation. I mean, it's a yes or no answer. Either you say it does mean the same or you say it means something different.
Well, I think that just give me a moment.
Yeah.
I think, my lady, what I have been trying to say is that you cannot look at section 47B2 in such a binary analysis, because the whole of section 47B is now such a uniquely different provision that you have to consider section 47B2 against the context of the rearranged, re-amended provision. That is my point. You cannot divorce it. So you cannot look at it in the same way as the other provisions. It's not
the same language could have a different meaning in a different section.
Exactly.
Precisely the same words, but a different interpretation.
I do say that, and I say that because of the purpose of this provision and the context of it, which is that this provision looks different to every other provision within Part 5.
Well, 47B2 doesn't, because it's exactly the same.
But everything that comes before it does.
Yes, well, we understand that submission.
That's my point.
Yeah.
That's my point. May I just move on and just very quickly outline what I say? I'll do it very quickly. The other interpretations beyond interpretation 1. So interpretation 2 is the repackaging argument, which is that an employee cannot bring a claim under section 47B against an employer if that effectively means repackaging section 103A into section 47B. And you've seen that in paragraph 38 of Wicked Vision, and that is one possible interpretation of the Wicked Vision EAT judgment. And we say that encounters the same problems as interpretation 1, as well as the fact that it doesn't engage with the impact had by section 98. So, for example, does section 98 also then prevent an employee accessing section 47B? Those are provisions that are usually brought hand in hand. So at what point does an ordinary unfair dismissal become repackaged? Interpretation 3 is perhaps a slightly different interpretation of Mr. Justice Bourne, which is that an employee cannot bring a claim against section 47B against an employer unless there are practical reasons that section 103A is not available. And you've seen the paragraph in Wicked Vision, paragraph 46, where Mr. Justice Bourne talks about the potential availability of a reasonable steps defence or the fact of being insolvent, etc. And we say, well, that is softer than interpretations 1 and 2, but it also begs all sorts of questions. For example, what are the practical reasons? When would you be permitted to amend? What happens if facts change over the course of proceedings, etc.? But in any event, we are clear that the question of enforcement of a claim cannot dictate who can be liable. And then, very quickly, interpretations 4 and 5 are what Mr. Bidnott-Edwards calls his potential Part 10 and actual Part 10 approach. And we think it's linked to the availability of compensation under Part 10. Like interpretation 1, the consequences of those would be that even a dismissal which was procedurally unfair would bar an employee from accessing Section 47B. And then finally is the interpretation 6 in Osipov, that is that the employee can have a claim via the detriment of dismissal for which the employer is vicariously liable. So Section 47B2 only prevents the employer being liable for its own act of dismissal under Section 47B.
So of the 6 that you identify, it's only the last one, Osipov, that works for you.
Yes.
The other 5 are 5 different ways of saying things which are not
Indeed.
In line with your submissions.
Well, we say that the other 5
are all different ways of saying something that you say is wrong.
Yes, exactly.
Well, would you accept that the other 5 seem to be various responses to Osipov which attempt to tiptoe around it or explain it away?
Well, my lady, that may be one way of looking at it, but it's another interpretation on the language of what
Right,
it
well,
means.
as far for this stage of your argument, you only need 2 possible interpretations.
Yes, indeed.
You
indeed.
don't need 6. So if there are 2, that's what you assert that it can be read. The plain wording can be read in 2 different ways. Now, would you like to just tell us how the plain wording can be read in the Osipov sense?
Yes. What?
Without going to purposive interpretation.
Yes, because what Lord Justice Underhill says is that the only thing that is excluded by Section 2B, the detriment in question amounts to dismissal within the meaning of Part 10, is the employer's own act.
Right, could we just have the paragraph number again? I know it'll be very familiar. But just
Yes,
for the
it's
notes.
Section 91.1.
Right, so it's back to 91.1.
Yeah. It's explained in the run-up to that between 75 and 91.1, but 91.1 is the clearest exposition of it. And that's what he says that means.
And where do we get that from the words in 47B2?
You get it from 47B2B. The detriment in question amounts to dismissal within the meaning of Part 10.
Yeah.
What he says about that is essentially...
Well, forget what he says.
Yes. Well, yes.
These words.
These words amounts to dismissal within the meaning of Part 10. The only person that can dismiss within Part 10 is the employer in respect of his own act.
The only person who can dismiss is the employer.
For the purposes of Part 10.
Yes.
But not for the purposes of Part 5.
Well,
Ow.
on these words, it's simply dismissal, which only an employer can do.
Yes, but what Lord Justice Underhill
So
says...
the difference between the employer's own acts and being vicariously liable for the acts of the employee, we don't get that from the words in 4B2.
We get that from we get that from Lord Justice Underhill's analysis that the what amounts to dismissal must be the same act that the employer. What is excluded by Section 2B must be the same act that appears in Part 10. And he says 1B clearly doesn't appear in Part 10. That provision of vicarious liability doesn't appear in Part 10 at all, not least because he says, if you look at the...
Is the answer that vicarious liability is not dismissal within the meaning of Part 10?
Yes. But he...
Right, well, that's it.
Yeah.
It doesn't depend upon what anybody's ever said about it. That's what you contend for.
Well, he goes beyond that, because he doesn't just say...
No, I'm trying to stick with the fact that if we're just looking at the meaning of the words, then it doesn't matter what anybody else has ever said about them.
Yeah.
Just looking at the meaning of the words, and we're trying to understand what they mean, what potential meanings, if there's more than one, might be. That's just a matter of language. And your argument, so that we have it as I understand it, is that dismissal brackets within the meaning of Part 10 of those brackets does not include vicarious dismissal.
Yes, exactly. Exactly. And what I say, my lord, is that once you accept that there's more than one meaning, or there is ambiguity in those meanings, the court has to turn to the canons of construction.
Right, well now we've detained you a fair amount in this, but I'm keeping an eye on the clock and the length of the permitted intervention.
Yes.
And we have, in the form of your skeleton argument with its annex, and the witness statement with its many annexes, which we have, all the purposive arguments,
Yes.
and what the consequences of this are and what the consequences of that are.
Yes.
Speaking for myself, having read the statement, read the skeleton argument, and looked at the index and some of the contents of the annexes, I'm not sure how you could improve upon that in oral submission. Can I allow you just another couple of minutes if there are any particular things you want to draw attention to post-hearing?
Could I ask the court, could I perhaps just point out a few, I won't take you to them, but just give you a few passages of a few relevant authorities on statutory construction in this sense. The first is Sullivan. No, Sullivan's not on statutory construction per se, it's actually about the purpose, so it's sort of the beginning of the purpose. But that's the paragraph, so it's Sullivan, page 840, paragraph 68 F to G.
Right, is this in the protect?
It isn't in our submission because it postdates our submission and Miss Raphael's witness statement. So
right, but is it in the long bundle?
It is in the authorities bundle.
Your one?
No, it's just in that there is in the supplementary authorities bundle.
Right,
it's
page
tab
number.
39.
Page number?
Page number 840, paragraph 68 F to G, and then page 845, paras 82 to 84. And then, just in light of the way the arguments have developed, could I please ask the court also to read, in respect of the case Harrods and Remnick, which is in the same bundle, tab 31, if the court could look at page 651 C to H and page 653 A to F. Also at tab 28, Holmes and Bradford RDC, page 582, it's red-lined. All
right, so in a nutshell, what do these tell us?
These effectively tell us that the court has to look at the purpose, and where there may be, for example, even two or more legitimate interpretations, the court should have regard to the purpose.
Yes.
They also, so that's effectively what they go to. But also I would like to turn the court to For Women Scotland, which also postdates our submission.
Well, these are very well-known principles, aren't they? I mean, I'm not sure that we...
They are, but I just wanted to turn the court particularly to paragraph 11 of that authority. My lady Justice looked at the first line, went to the first line yesterday, and I would just invite you to look at the whole of that. And also Monarch Airlines, page 614, also redlined in the same. And finally, I would just ask the court, and I think finally I would just ask for the indulgence of Kinterval. You've seen it, we've recorded it in our submissions. It's paragraphs 8 to 9. And the simple point I want to make and perhaps end with is that it says two things. Any controversial provisions should be read in the context of the statute as a whole, and the statute as a whole should be read in the historical context of the situation which led to its enactment, and also the rule that a statute is always speaking. And we see that goes to the fact that you have to look at the context and uniqueness of the provision section within which section 47b2 forms. And we say, in short, that Osipov achieved that.
Thank you. Well, thank you, Ms. Jolly, and Mr. Masters also. I don't mean to bring your submissions to an abrupt end, but in fact, we've benefited from them for rather longer than than was allowed. The court very much appreciates the work that's gone into this assistance, but you will, for your part, appreciate that because you have a particular point of view. It's very important that intervention doesn't overspill.
Yes, indeed.
Because, of course, what you've said isn't agreed to by about half the other people in the court.
Yes,
so
indeed.
We have to have mind to fairness in that
Yes,
sense.
indeed.
But what you provided us with will be useful. Thank you very much.
Thank you very much.
Yes. So who's going first?
Your Lordship's looking at me, but I think in the timetable, Mr. Bidnell Edwards has a right of reply. We put that in.
Yes. I thought half an hour each looked opulent, but I'm sure you'll be able to to boil it down.
My Lord, it may please the court to know I don't have much to say at all. I have raised this issue that my learned friend, Ms. Matrahi KC, had some points in reply. Mr. Jupp KC's submissions address in some detail some of the points raised by my learned friend, and I, given that I'm not going to take very long at all, I certainly agree to Ms. Matrahi KC being able to defend her own case, as it were, but it's a matter for the court and for the parties.
Yes.
My lords, my lady, of course it would be, I don't have a formal right to reply, and so I would be begging the indulgence.
I've lost count of the score here, I'm afraid. But,
what I would be seeking is no more than 5 minutes, and in circumstances where Mr. Bidnell Edwards would not be using his 30 minutes or anything remotely like that,
yes.
It shouldn't detain the court any longer,
unless
and nor would I have any reply.
Raises any concern about this, I'm perfectly happy that you divide your efforts.
Thank you.
Because I think you're not talking in a partisan way about your individual clients. I think
No.
it's a point of law, and we benefit from.
And indeed, I think, as indeed has already been recognised by the court and said by a number of parties, the statutory construction point will stand or fall in the same way.
It's a common point. All right. Well, because we're approaching it in this way, you have your 5 minutes.
Thank you very much. I'm very grateful. So if I may first make a couple of observations on practicalities and secondly address matters of statutory construction. So firstly, just dealing with the example given by Mr. Jupp and then adopted by Protect, Ms. Jolly, the example of the whistleblowing employee working for a local government organisation. Just to make a very simple point, which is that there are numerous possibilities of appeals to cases where there may be perceived unfairness in a broad layperson sense.
I think
to the claimant.
your solution is basically so what, is it?
Yes.
I mean, is it?
It is.
I mean,
It's an inevitable part of litigation that there may be claims that cannot be satisfied, even by where a claim is brought successfully and they have a judgment in their favour. As a matter of practicality, if you're suing a government department, they're good for the money. If you're suing a start-up or a business that is less than solvent, you may not. I'll move on. You might want to note, of course, that in Osipov, the bar is not so high that a claimant could not succeed in a Section 103A claim. That indeed was a case where such a claim succeeded. The issue was then, at least in part, potentially enforcement. Now, the second point I wish to make, which starts to go to the interpretation issue, is that the interpretation that's urged on you by the claimants in these conjoined appeals does not, in fact, remedy the perceived unfairness in any event. You've heard it's not fair that workers get some form of being able to bring dismissal claims in circumstances where employees do not. We say that's a fundamental misreading of the legislative scheme, but even putting that to one side, in my submissions, I raised the example of an individual employer who isn't a company, myself, for example, employing a personal carer because I'm a disabled person, or perhaps employing a nanny, in circumstances where there couldn't, even on the claimant's case, be any potential 1A or 1B liability, and so there would be no vicarious liability that arises, and so that claimant would only have a claim under Section 103A. There's no indication in the Act that that sort of salami slicing is permissible, or should be permissible, to seek to differentiate between claimants who work for sole traders or individuals in that way. A person who's a nanny or a personal carer or a gardener or whoever might be in just the same sort of vulnerable position and would be just as likely to suffer victimisation due to whistleblowing as anyone else. Indeed, they might be more in need of such protection. As to the protect submissions, Section 47B2 is not unambiguous. It is not ambiguous. Not ambiguous. You might say that with 11 counsel in the same room, it would be extraordinary if they came to the same interpretation on any statutory section. What we're looking at here is an objective reading, not simply the way in which submissions could be made. We're looking at the plain and natural meaning of the words. And in my submission, what you've heard is something that makes clear quite how strained some of those interpretations are on behalf of other persons other than the employers. In terms of guidance to the tribunals, the key matters to consider here are, firstly, what in substance is the allegation that is being made by the claimant, i.e., is it one that amounts to dismissal? And those key words, amounts to dismissal, are very, very important. And secondly, who is the allegation against? So, in both of these appeals, and indeed in almost all cases, I can't think of one that this doesn't apply to, these are claims which are brought against the employer. They might be claims where they are also brought against an individual co-worker, but they are certainly claims that are brought against the employer. And if we look at Section 47B2, that has two key parts after the preamble, and I'll come to the preamble right at the end. The first constituent part are what, if we look at, this is at page 75 of the Supplemental Authorities Bundle. It's the top of the page. So after this section does not apply, where? It says, firstly, the worker is an employee, putting that to one side. Everybody agrees we're dealing with employees here. So in B, the detriment in question amounts to dismissal. That's the first part we need to look at. And secondly, within the meaning of Part 10. So on the first part, what amounts to dismissal? In the cases that are being brought here, it is going to be the co-worker dismissed me, whether they are somebody low level or whether they are the chief executive of the company or anybody in between. That's a claim under Section 47B1A, and the claimants themselves rely on Section 47B1B. And if we turn back to page 74, that is clear at the end, after the comma. The effect of 47B1B is that thing, the dismissal, is treated as also done by the worker's employer. So when the claimant is bringing a claim against the employer using the composite of 1A and 1B, they are saying this is an act of the employer. And indeed, the claimant is bringing the claim against the employer on that basis. In substance, it's a dismissal claim. We say it is a dismissal claim. And appeals to form are not helpful here. Mr. Jupp addressed you on, well, conceptually it might spring from this route or that route. Even Lord Justice Underhill in Ossipov, paragraph 59, page 170 of the Core Authorities Bundle, said that what we need to look at is whether in substance we're talking about a dismissal. And that too goes to what Mr. Justice Bourne dealt with as the repackaging of paragraph 38 in the Core Authorities Bundle at 207 in Wicked Vision. So if there is a difference, then it is a distinction without a difference, and it's not one that falls outside amounts to dismissal under 47B. The second part of B, 47B2B, is whether it is a dismissal within the meaning of Part 10. And in this claim, it's brought against the employer, it's the Employers Act that they're complaining of by reason of 1B. So we've got a dismissal treated as the Employers Act, where the claimant claims against the employer, challenging the lawfulness of the dismissal on whistleblowing grounds. Now that is evidently a claim which could be a Section 103 claim on which 47B2 bites. Let me just take you back to 97 of the Supplementary Authorities Bundle, which is Section 103A. It reads, an employee who is dismissed shall be regarded for the purposes of this Act, and so on. So it's about a dismissal, and that's what the claimant is complaining about, using the composite of Section 47B1A and 1B. It's also the result if you look at Section 95, which is at page 93 of the Supplementary Authorities Bundle. That reads, for the purposes of this part, an employee is dismissed by his employer if, and then we've got A, B and C and 2A, and let's look at A first, but I say the same analysis applies to all. The contract under which he is employed is terminated by the employer. Well, in this case, we know that it's not being said by any of the appellants that the contract under which they work is not terminated and that in fact persists, notwithstanding that there was some sort of dismissal by the co-worker under Section 47B1. We know that under 47B1B, that dismissal is done by the worker's employer. And furthermore, as I say, there's no case to my knowledge, whether in these appeals or elsewhere, where the claimants say that the contract of employment in fact hasn't been terminated or otherwise falls into one of those provisions on Section 95(1) or B, 1 or 95(2). What I didn't hear in the submissions of Mr. Jupp or Messrs. Solomon or Milsom was any reference to what amounts to dismissal under Section 47B2. That is something that, as I say, is clear and unambiguous, and all the more so when it comes to looking at the preamble. The preamble, if we go back to page 75, says, this section does not apply where. That's clear and unambiguous. And lest it be overlooked, this section does not apply where, if we look up, sections 47B1A through to E are part of section 47B. There is no limitation to 47B1. There's no explanation of how one could sidestep the fact that 47B2 does not have any express carve-out saying, save for claims brought under section 47B1B, this section does not apply, or subsection 1 does not apply where, etc., etc. And indeed, the draftsperson could have drafted a separate section, for example, headed detriments brought against co-workers and vicarious liability, a new section 47BZ, to which 47B2 would not have applied. So we say that any references to conceptual or what I might say are theoretical or academic differences don't take into account the plain reading of 47B2 or the fact that we are not simply looking at a technical meaning of dismissal, but what amounts to dismissal. And then finally, in terms of the meaning of section 91(1), it was said against me that I disavowed section 91(1), the final sentence, which refers to...
Oh, sorry, this is paragraph 91.
Yes, sorry, paragraph 91(1). We must, of course, guard against treating Lord Justice Underhill's
like
judgment
statute.
as if it were a statute.
I was just about to do that, Gary.
What we must consider is what is the meaning of "its" in that sentence. So the meaning of that sentence, the last sentence, is not clear. If what Lord Justice Underhill was seeking to draw was a distinction between claims brought under section 47B1B and section 47(1) claims, then we say that's not a correct distinction for the reasons that I've already given on the interpretation of section 47B2. If he was not, and he's saying that both 47B1 and 47B1B claims would be covered, then we would agree. And save for the fact that I would seek to reserve my position in respect of the correctness of Osipov, even insofar as I've accepted it thus far, should we go to the Supreme Court, Those are my submissions, and I'm very grateful to the court for permitting me that additional time.
Thank you.
Thank you.
Yes, Mr. Bidnell.
Thank you, my lords, my lady. I only have really two points to pick up. It may be a question that my learned friends, the appellant, have to address in respect of what does a dismissal amount to if it is a dismissal that is not done by the employer. So it cannot include the termination of the contract itself, couldn't include a loss of earnings award, and could only be limited to, say, the manner or the words used as a one-off act if it is done by an individual. So that's a point briefly made. We say that following their path leads to a potential of absurdity of its own. The other matter we invite the court to consider is the judgment in Johnson and Unisys Limited. Essentially, it's not possible to award compensation for the manner of an unfair dismissal using the provisions in Part 10. There's a passage, Supplementary Authority Bundle, page 1149, paragraph 49, which essentially reflects that common law decides cases according to principle and cannot impose arbitrary limitations on liability because of the circumstances of the particular case. Only statute can lay down limiting rules based upon policy rather than principle. We say that is opposite to the question for the tribunal also concerning Part 10. But that is it, my lord. I'm grateful.
Thank you very much indeed. Yes, Mr. Sullivan.
My lord, you're looking at me with relief that it's almost over.
No, I was thinking how long it was since we last heard from you. Anyhow.
Can I express my gratitude for all those appearing pro bono? My team and I appear pro bono too. So I think it's pretty much everyone in the room, apart from Mr. Bidnell Edwards, who I think will be buying everyone drinks.
Well, I don't mean this light-heartedly. I do think it's an extraordinary state of affairs that the bar is willing. I appreciate it's an interesting point that has stretched you all, but nevertheless, we're extremely appreciative that you've been willing to come and argue this point, and everybody benefits from it, and I hope in one way or another you all will as well.
Well, those words mean a lot, my lord. Thank you. Your lordship asked Miss Jolly what amounts to dismissal within the meaning of Part 10 means. We would put it like this, with respect. That amounts to dismissal within the meaning of Part 10 does not include liability for a detriment amounting to a dismissal by a co-worker for which the respondent is vicariously liable. Now we say all of that.
Hang on a minute, let me just make that.
Yeah, sorry.
Dismissal by a co-worker for which
an employer.
An employer
is vicariously liable.
Yeah.
It doesn't include liability for a detriment amounting to a dismissal by a co-worker for which the employer is.
So that's a more careful version of what I noted before. In quotes, dismissal in this section does not include vicarious dismissal.
It doesn't include a detriment amounting to a dismissal for which the employer is vicariously liable. So 1A creates liability for co-workers, and OSPOF says that liability includes detriment amounting to a dismissal, and 1B makes the employer liable for that thing, which is a detriment amounting to a dismissal. And so OSPOF says, our analysis of OSPOF is that everything I've just said is the conclusion and ratio, necessary conclusion of the case. My learned friend, Miss Montraghi, would stop before the final phrase for which an employer is vicariously liable. But I think, as I understand her position, everything else she agrees is the ratio of Osipov, which has preserved her position for the Supreme Court. So I should say that I agree with Mr. Jupp. He explained to your lordship and my lady quite correctly how initially section 47 provided for 47B for a worker not to be subjected to a detriment, and the subsection 2 exclusion obviously applied to that obligation, and where the detriment in question amounted to dismissal. It's obviously the employer's own act of dismissal at that point. And at that stage, as Ms. Montraghi showed you, it's very similar to a whole host of other similar provisions where there's an exclusion in respect of Part 10. But then 2013 introduced a whole new raft of rights for workers, including the ability to bring a claim against a co-worker, and for which an employer was vicariously liable. And what Mr. Bidnell-Edwards told you this morning is that, therefore, his reading is that 47B1 is entirely the same as 47B1B. That's his submission to you, that it's the same liability. So it's the same thing. A dismissal by an employer is the same as a detriment amounting to a dismissal by a co-worker for which the employer is liable. And indeed, Ms. Montraghi, I think, made that submission to your lordship just now in her reply. We say that cannot be right, that the rights that were introduced in 2013, which include 1B, are obviously different to the rights which previously existed, and that, as Mr. Jupp said, primary and secondary liability for vicarious liability are different, and the Supreme Court authority explaining that vicarious liability is a form of secondary liability. And in respect of my Lord Justice Coulson's question about the requirement to bring a claim against a co-worker if you're relying on 47B1B on vicarious liability, the short answer is no. But in respect of the case before your lordships, I showed you the Employment Tribunal, where the Employment Tribunal said there's no requirement to bring a claim against a co-worker, and the appeal by the respondent, Mr. Bidnell-Edwards, Ms. Montraghi's clients, to the Employment Appeals Tribunal, where that point was specifically addressed and rejected by Mr. Justice Bourne.
That's the paragraph 53.
53,
yeah.
Correct.
We saw some earlier paragraphs where it was a point of distinction that he was drawing with Osipov.
It was
so it wasn't entirely clear, but you referred us to 53.
He rejected it in terms at 53.
Yeah.
And he says it's not, for the reasons given by the Employment Tribunal, you don't need to bring a claim against an individual. And that's right, and the terms of the statute show that's right.
That hasn't featured very heavily in the argument before us.
It was raised by...
Yes, but I'm thinking, when I was reading for the appeal, I thought that this was a fairly prominent aspect to the parties' competing arguments, the absence of a claim against an individual, but it doesn't seem to have been much referred to.
No, I mean, rightly, Ms. Montraghi has not pursued it because there's no respondent's notice. It's actually not open to her to argue this point. But it's...
Anyway, you say paragraph 53 deals with it.
Well, it deals with it, but it's substantively right. So that's the answer in this case. It's substantively right because the statute makes it clear that you don't need to bring a claim against a co-worker. You can just bring the claim against the employer. That's what the terms of the statute make that clear. It's a deemed liability.
Which provision?
47B1B on page 74 of the supplemental authorities bundle, where a worker is subjected to a detriment by anything done as mentioned in subsection 1A.
Yes.
That thing is treated as also done by the worker's employer. So anything done is a deemed liability, and that's the ability to claim it. As a matter of fact, quite often in the Employment Tribunal, you've got claims where you can bring claims for vicarious liability and claims against the individual respondents in lots of discrimination claims. And employment tribunals discourage claims being brought against individuals. They think it's, why would you do that? There's no benefit to you, and it causes more hardship to the individual when the employer is going to be
Is there not a stage where you actually have to find that the individual was liable
but that's
before
all
you go on to find vicariousness?
quite exactly.
And in order to find an individual liable, there may be issues of proof and fairness.
Well, there may be a whole hit. I mean, fairness may or
It's
may
quite-
not
it's
come
quite
into
hard- It's quite hard
detriment.
to say that X is liable for having done something without having asked X about it. I mean, but maybe these things happen.
It's almost always the case when you're suing a corporate body that the corporate body will have to call individuals to give evidence as to why things happen. In this case, it's just that the corporate body is liable because of 47B1B, and it will marshal its evidence as it thinks fit in any given case. But the meaning of the provision 47B2 was considered in detail in Ossipoff, and there is some element of agreement between the parties of what the ratio of Ossipoff is. Ms. Montraghi agrees that some bits of 91 reflect the conclusions. But can I very briefly show you a couple of paragraphs where this specific point was considered? Your lordships will, my lady, will see in the core authorities bundle, at paragraph 46, page 165, or your lord, my lords are looking at it in the different places. Paragraph 46. This is the basis of the appeal before the Court of Appeal. By reason of 47B2, neither of the individuals could be liable for the claimant in respect of instruction to dismiss, nor could they be liable for losses. So those are the 2 points under ground A. And if you go forward to paragraph 56, page 168 in the bundle, but paragraph 56, this was the appellant's case that the section doesn't apply where the detriment in question amounts to dismissal within the meaning of Part 10. Mr. Stillitz, for the unsuccessful appellants, contended that the present case falls within the terms of the exception 47B2. He said detriment amounting to dismissal where the losses are the losses flowing from the dismissal, and the act said to be the detriment is in substance nothing more than dismissal. So that was the argument advanced before the Court of Appeal, which is precisely what Miss Montraghi is arguing before your lordships, my lady. At paragraph 60, the court set out what the respondent's position, and Miss Jolly, protect, saying that's wrong because within the meaning of Part 10 goes further, language of, at F, the language of the key provisions explicit, 94.1 refers to an employee being dismissed by his employer, and so on. And then at 61, the Court of Appeal says this is essentially what Mrs. Justice Sinler, she then was, accepted in the Court of Appeal. The court went on at 63, bottom of 171, to highlight that Mr. Stillitz focused on the words within the subsection. He said within the meaning of Part 10 did no more than define the word dismissal, and that Mrs. Justice Simler was wrong. But the court rejected this, and the conclusion was partly at 77, page 175, I'd hold that 47B2 does not prevent the claimant proceeding against the directors under Part 5 on their basis of the responsibility for the dismissal itself. And then further at 91, page 179 to 180, which you've had read to you ad nauseam. So I'm sorry, that was rude. I shouldn't have said that.
No.
A number of
No,
times.
it's quite funny.
We're familiar with the passion.
So, when Miss Montraghi accepted before your ladyship, your lordships, that paragraph 77, which I've just shown the court, was part of the key holdings, we say that is in effect determinative of this case, because it shows that section 47B 2 does not preclude a detriment of dismissal claim being brought under 1A, and 1B simply makes the employer liable for that act. Yeah. My Lord Justice Jackson will remember that when Miss Montraghi told the court that 77 was the ratio of Ossipoff, your lordship said it's not the ratio, it's just a necessary conclusion, and the ratio is the reasoning. But as a matter of fact, Miss Montraghi was doing nothing more than Mr. Justice Bourne said, because he said in terms in Wicked Vision that 77 was the ratio of Ossipoff, paragraph 41, page 208 for your note. So that element of Ossipoff, on anyone's view, cannot be challenged now by Miss Montraghi or Mr. Biddle-Edwards. Whether it's the conclusion following from the ratio, or the ratio itself doesn't matter. It's what the Court of Appeal held was a necessary part of its reasoning. And with great respect, only the Supreme Court can overrule that. And it's what Mr. Justice Bourne said too, in this case, in Wicked Vision. And there's been no respondent's notice, as I said. So what is the effect of that? If that's the starting point, and that's what everyone agrees is the starting point, the effect is that a claim can be brought in respect of a detriment amounting to a dismissal against a co-worker. Your lordships were treated to a whole series of submissions by Miss Montraghi, which said that dismissal can never be within this section. But that is entirely contrary to what Ossipoff found. And of course, what Ossipoff said in the Court of Appeal was that it goes beyond that, that it's open to an individual to bring a claim for that dismissal, detriment amounting to a dismissal, as a vicarious liability claim against the employer under 47B1B. And that was part of the essential conclusions at the notorious paragraph 91. We say that's the ratio. Miss Montraghi says it's not. But even if it's not, we say the terms of the Act make that clear, that you can simply pursue a claim. And no one explained to the court why it's possible that a detriment amounting to a dismissal is not excluded under 1A, which is what is said, what is accepted as the ratio by Miss Montraghi, but is then excluded under 1B. How on earth can the same clause, subsection 2, have a different effect in respect to the previous subsections? It can't. And that's why Ossipoff went on to say, obviously, therefore, vicarious liability flows, because it's the same point. And that's why it's part of the ratio of Ossipoff. And we say that the fundamental part of Miss Montraghi's submission and Mr. Biddle-Edwards' submissions are not open to them. It would only be open to them in the Supreme Court. Further, significantly, we highlighted some of the difficulties in Wicked Vision. I highlighted, and I went through I criticised paragraph by paragraph the Wicked Vision, and I highlighted in particular paragraph 46, page 209 of the Core Authorities bundle, where Mr. Justice Bourne appears to accept that some detriments amounting to a dismissal may be brought against an employer And he said sometimes it's necessary because the employer could be insolvent, for example. So the fact that Mr. Justice Bourne accepts this proposition, we say, is directly contrary to the rest of his reasoning where he rejects it. Secondly, wasn't addressed at all or explained to you by my learned friends sitting next to me. Thirdly, it's directly contrary indeed to Ms. Montraghi's submission that the effect of 47B2 is to prevent a claim of dismissal per se, and in particular in respect of subsection 1B. And with respect, that submission is not open to a party without a respondent's notice. And it is justified, it seems, by Mr. Justice Bourne on the basis that there is only a technical distinction between employer and employee in this case, which, when you asked, my lord, Miss Montraghi about that, she did not seek to defend that position. She said an employer always acts through its employees. So once you've got, so my submission is that what appears to be a strange anomaly at paragraph 46 is simply the inevitable position that you have to reach if you accept that subsection 1A includes liability for a detriment amounting to a dismissal. A couple of other short points, if I may. Miss Montraghi and Mr. Bidnell Edwards addressed your ladyship, my lords, on the case of Melia. This case was dealt with directly in terms in Ossipov. So if your ladyship, your lordships, turn to 177 behind tab 4 of Core Authorities Bundle, you can see that the Court of Appeal addressed the case of Melia and Magna Kanzai, paragraph 85 onwards, and it was held at paragraph 85 not to be inconsistent with any of the conclusions. My learned friend, Miss Montraghi, took you to paragraph 15 of Melia, and if you turn the page at 178, paragraph 15 is quoted there by the Court of Appeal in Ossipov. My learned friend next took you to paragraphs 32 to 34 of Melia. They are quoted at paragraph 178, page 88, paragraph 178 of Ossipov. And all the arguments that were advanced before this court were made and rejected by the court in Ossipov. So the conclusion that I asked Ms. Montraghi to read out to the court at the very bottom of paragraph 90 is that the issue was not before the court in that case, and Lord Justice Chagdwick's language cannot be treated as having any bearing on the question we have to decide. We say, in fact, that's part of the ratio, that's part of the analysis in that case. So it's simply not open to this court to review that analysis in the context of this subsection. But in any event, that's right. My Lord, Lord Justice Jackson asked at one point why a claimant might wish to bring claim under Part 5 and not under Part 10. What the answer you got from Miss Montraghi is this, and this is my note of her answer. Whichever case is adopted by dismissal by a co-worker, you end up being able to repackage as a 103A claim because fundamentally it's a dismissal. It's not the co-identity of employer and dismissing employee. Our submission is this. That is not the basis of Mr. Justice Bourne's decision. It's Mr. Justice Bourne's case that the explanation for his difference with Ossipov, paragraphs 49 and following, it is that the employer and the dismissing co-worker are the same. But fundamentally, if Ms. Montraghi's submission is correct, it means that Osipov is wrong. A claim against a co-worker for a detriment amounting to a dismissal could potentially be brought as a 103 claim. Mr. Bidnell-Edwards went further. He said that Osipov had simply ignored this point. With great respect, that submission is untenable. In Osipov, the facts were set out by the court at paragraph 1, and these were these are stated, as I said, to be the only facts upon which the appeal turned. That's what the court says at paragraph 24. And at paragraph 1, in subparagraph 3, bottom of page 153, top of page 154, the court set out that the Employment Tribunal accordingly held that he had been unfairly dismissed by IPL by reference to section 103A of the ERA, which prescribes whistleblower dismissal. That decision is not challenged before us. So the court knew that there had been a successful 103 claim which hadn't been appealed. Somehow, Mr. Bidnell-Edwards is able to make the submission to your lordships, my ladyship, that the court had forgotten by the time it got to paragraph 91 what the 3 or 4 short paragraphs of facts were that it set out at the beginning. That submission is plainly wrong.
So what happened was that IPL tried to appeal,
Yes.
then collapsed, and the appeal was dismissed by consent.
Yes.
I mean, that's the peculiarity is between
It,
Mrs. Justice Simler and the Court of Appeal hearings.
yeah, IPL was represented in the Employment Appeals Tribunal.
Yes, yes, it played a full part in the
Yes.
EAT, but had disappeared by the time
Yes.
it came to this court.
But whether it was there or not,
No, it wasn't relevant to the point you were making. I was just filling in.
factually, your lordship is not correct. The point I want to advance is that my learned friend's suggestion that these are exclusive provisions and you've got to bring one claim or the other is plainly wrong. There was a claim under 103A. It was successful. The Court of Appeal was obviously aware of that, and it nonetheless found that separate claims could be brought for detriment amounting to dismissal and for vicarious liability of the employer at the same time. So this.
I'm just putting this together. So what has it found? That IPL is double liable?
No, you can't have double recovery. Of course, you can't have double recovery.
No,
but you'll be.
But so in a sense, its conclusion about the liability of IPL was evidently either part of its reasoning or not part of its reasoning, but it's not part of its decision.
So my submissions are these, that the Court of Appeal plainly knew that there was a 103A claim that's been successful, and it plainly isn't correct to say that you can only have, you've got to choose either bring a 103A claim or go for dismissal under 47B, because in this case, Osipov is an example of where both happened at the same time. You may, however, be able to recover under both 103A and 47B against the employer because the remedies are slightly different. So you can get a basic award under 103A and you can get injury to feelings and personal injury damages under 47B, but not...
So are you saying you can sue under both?
Yes.
You can pursue under both and you can succeed under both?
Yes. Yes. It's not a surprising submission, my lord. It's the conclusion that the Court of Appeal in Osipov reached.
Well, I just don't think that is right. There was nothing about different types of recovery in Osipov. And at 60, Lord Justice Underhill summarises the point that the paragraph that we're also familiar with, that only gets Mr. Stilts to first base, although Mr. Carl made no concessions on the question whether the pleading instruction recommended a mandatory dismissal. His primary case, supported by Ms. Jolly for protect, was that Section 47B2 would, in any event, still not apply to the claim as against the directors, in brackets, as opposed to IPL. Clear distinction in the arguments that were being made. There was still a claim over against the directors, and Lord Justice Underhill found that there was. But he made no order against IPL, no, because it wasn't an issue.
It wasn't an issue.
Yeah. But if it wasn't an issue, it couldn't be part of the decision.
It was party to the claim. It had been party to the claim, and it was party to the EAT decision, which was upheld by the Court of Appeal, which said you're liable under 103A and there's liability under 47.
Right, so we need to look at what Mrs. Justice Similar found. Do we?
No, not beyond that simple proposition, which is set out for you in the Court of Appeal. The simple point I'm making to the court now is in response to a point that my learner from Mr. Bidnell Edwards made to your lordship, your ladyship this morning, which was you can't bring both claims at once, and you plainly can. And there's nothing in the Act which says you can't. And although you can't have double recovery, there are different types of remedies that you might get under the different sections. The way in which it's been put to the court has changed over time. Mr. Bidnell Edwards has put it in a variety of different ways. And what Miss Montraghi said to you at one point was that, and I wrote down the words, 47B2 excludes dismissal claims which could have been brought under Part 10. That isn't the wording of the statute, and it's not a permissible gloss. The words are amount to a dismissal, and the meaning of that is as set out in Osipov. If it excluded claims which could have been brought under Part 10, Osipov would have been decided differently. As to the dead letter question, which your lordship asked me when I was first on my feet, and remains live, if I may say, as an issue. Apologise, it's late. The different sections have real value. So interim relief and reinstatement are only remedies you can get under 103A. You cannot get interim relief. It's incredibly important, incredibly valuable and powerful weapon for an employee who claims whistleblower dismissal or dismissal. It's not available for a detriment claim. Conversely, under Section 47B, you can not only get injury to feelings, but damages for personal injury, which you can't get under a dismissal claim. So they cover different types of remedy. It's not a 47B2 isn't a dead letter. And of course, the dead letter argument was considered and dismissed at 74 in Osipov. Of course, what Miss Montraghi accepted was that the causation test is lower. And she said, and I wrote it down, it's unquestionably easier to get home under 47B, but that's precluded under B2. It's plainly correct that it's easier to get home under 47B because of the different test, as has been canvassed before your lordship, before your ladyship. But that shows precisely why a purposive construction of the Act should lead to the conclusion that our claim succeeds. So just in conclusion, if Mr. Bidnell Edwards and Miss Montraghi are correct, the meaning of detriment amounting to dismissal is different under section 47(1)(a) than it is under section 47(1)(b), notwithstanding that 1b provides simply for vicarious liability for the very same thing. I make 3 simple points about that. First, it creates an absurdity in respect of enforcement. You've heard some submissions already about that. Secondly, it is contrary to what we say is the ratio and, on any view, the reasoning on Ossipoff. And thirdly, it would leave the law in a mess where, if that is your lordship's, your ladyship's decision, there are now, we say, conflicting decisions of this court, which is unhelpful. And if the position is that that's the conclusion in any event, we say the starting point is the court is bound by Ossipoff, and any other position must be taken only by the Supreme Court, can only be taken. Can I have one moment? Unless I can help the court any further.
No. Thank you, Mr. Sullivan. Very well. Well, thank you all for the preparations and the argument and managing to fit the argument within the time estimate, and for helping us with answers to our questions. We'll obviously take time to give this some thought. It's not easy. And we will let you have our draft judgments in due course for the usual purposes of editorial correction of any obvious errors of fact, and the creation of draft orders, please, in each of your appeals to reflect the terms of our decisions. Please respect the terms on which the draft judgments are shared with you, and we won't need to trouble you to return for the handing down formally of the judgments, which will be done electronic in the normal way. Thank you all very much.
All right,